I'm going to talk to you about how I did intake on a potential lawsuit under the American with Disability Act. So, what the first thing I did was I checked with a client on whether or not she had filed a charge of discrimination under the ADA with the EOC on time, which is in Texas, you have to do within 180 days or 300 days. I checked off that box. So the next step is I ask her about her disabilities, go into details with that, and then I checked on the accommodation that was requested by her doctor from her employer. So in this particular instance, there was an accommodation request of changing her hours from 8 hours a day to 4 hours a day and reducing her work days instead of 5 days a week, 4 days. So instead of working 9 to 5, her doctor wanted her to be placed on a modified schedule of 4 days, 4 hour days. The employer said no, they couldn't accommodate her and they fired her. They let her go. So the next question that I and any other employment lawyer faced with the situation would face is we check on the circumstances given by the employer on whether or not the reason they gave for denying her accommodation request is reasonable because it's called reasonable accommodation. You can't deny reasonable request for accommodation under the ADA. So this lady has a medical condition that says that she has to work half the hours that she used to work. And so there are four accounts payable person, and she was one of them. And so whether or not the employer was reasonable in denying it might not be. It depends on the facts. We don't know from the outset on what her workload is. So the next reasoning or the next step in my mind is we have to contemplate whether or not her work could have been picked up by the other three accounts payable person, or did she have a dedicated account? If the answer is that she just sits around most of the time and they don't have a whole lot of work, her coworkers could pick up the slack, then that's one thing.